Good day to you. This is being recorded during the pandemic of 2020. We miss not having the opportunity to join you in your districts for the spring district meetings. We miss our opportunities to interact with you as we have done almost every year for many years past. I hope you're safe and I hope that your community is bearing up under these circumstances as well as can be expected. Know that we are here for you, and we're going to do our best to look at how you do your job regarding public hearings and final land use decisions with this video training that we are making available as a poor substitute for a chance to get together and talk face to face. The land use arena and what we have to do in planning and zoning is already a big enough challenge. But add to it a pandemic where individuals are ordered to be housebound and many ordinary activities of daily life are curtailed. And it makes the entire process a bigger challenge for everyone. It's not only a problem for you who carry out your public duties, but for all of your residents who may want to come and participate in the public hearing process. So let me start with one general recommendation that you might want to consider. Unless the law requires you to have a public hearing at a particular time, give some consideration to delaying the hearings until the world opens up a little bit more than it is currently in April of 2020. The public hearing process by long distance, even with the governor's approval of hearings or meetings where no one is present at a physical location, still will yield a number of challenges that are substantially difficult, much more difficult than they would be if you could be there in person. So unless the law requires, considering not having a hearing may be one of the best options you consider. Now I'm going to start in the public hearing process at the end because that's an important principle that I'd like to ask you to consider. The conclusion is where you hope you wind up with a successful decision and an intent to reach a conclusion that comports with the law, that allows people to have been heard, and that will shape your community in a positive way for years to come. The first thing you need to know is that you have to have a destination in mind. If you don't, you will wander around looking for what's significant. Sometimes what is perceived as significant actually is outside the realm of what you need to consider. The process should be shaped so that you reach that end with a minimum of steering, pushing, and prodding, if you will, because people will immediately feel an emotional reaction when they hear about many land use issues that will be decided by your governing board. There are two major components that you need to look at. What's the final decision we're going to reach, and will we document it adequately? And the process of getting to that final decision, having a procedurally sound hearing process that leads to those final decision points. All of those are critical, and many of the participants are not in your employ. So they're going to come and bring whatever intellectually or emotionally affects their desire to participate. The final decision essentials must be based upon criteria found in your laws. One of the key parts of the planning and zoning process is a comprehensive plan. And the plan is particularly important regarding zone changes. State law requires that zoning changes be made in accordance with the policies contained in your plan. Sometimes it can be tempting to look at the future land use map of your zoning or comprehensive plan and have that seem to be a mirror of your zoning map. But that is not what the state law requires. It requires you to consider the policies that are important for this process. Secondly, your zoning ordinance is a key. Your zoning ordinance establishes districts or areas where certain uses are allowed, certain conditionally allowed uses are up for consideration. And then your other applicable ordinances, including a plan unit development ordinance or a subdivision ordinance, the standards that you have to judge an application by must be set forth in express terms. Now, I exclude from that the zone change process because it's governed by the policy of the comprehensive plan. But otherwise, your ordinance must have standards that set forth exactly what an applicant must show. You have to identify the basis for what gets approved and what doesn't, what is compliant and what is non-compliant. Decisions in the end must be written, and they have to be accompanied by a reasoned statement. That reasoned statement is intended to meld together the criteria from your ordinance, the facts that come into the record, and the rationale or reasons why you reach the conclusions that you have. In the end, recognize that any final decision can be appealed to the district court, and one of the potential remedies is to invalidate a decision that isn't soundly founded on the laws and the criteria included in your ordinances. Today is a different day. There is a new meeting reality. Many times your meetings are going to be conducted in a completely remote control setting with nobody home. How do you enable attendance? It's one thing to make sure that your meeting room doesn't have impediments that keep people with a disability from attending. But now that disability has a new dimension. I think we all need to recognize that in this world there is a digital divide. And we all have to surmount it in multiple ways. The first consideration is, can we put on a public hearing in a competent manner? One that is capable of reaching competent recipients in our community. Secondly, the barriers to participation shouldn't be too great. Your residents should be able to simply connect to the process. That's essential, particularly where there are public hearings, where they have an expectation that they will be heard. And third is a physical limitation. Does your community have high-speed broadband access that is sufficient to let all of these integrated pieces work together? For public hearings, how you enable participation is much more challenging. People need to be informed about the relevant materials and need to know how they can take part in the public hearing process. In order to do that, they have to be able to witness what others are saying, be able to know what is in the physical record, and be able to assess representations by an applicant or by others who are participating. I should make mention at this point that parallel with this video, I have prepared a written article that should be available on the AIC website that sets forth a number of considerations as you work to pull together a digital reality for your public meetings and public hearings. Additionally, the Association of Counties, the Idaho Association of Counties, has prepared a written worksheet that AIC has already posted online that outlines some of the technological options that exist in today's rapidly changing world. I've chosen to look at this from the perspective of several different persons who play a role in any land use decision. Start with the applicant. The applicant's rights are pretty much set forth by law. There are constitutional rights and there are statutory expectations that need to be respected. At the same time that the law protects the applicant also has a burden of persuasion. The applicant must show that his or her application complies with the standards established by law. There are major differences between experienced applicants who have been over this road many times and those who have never done this before. They have never been an applicant, never been involved with the planning and zoning process, but they know that the development economy is good and that this might be a way to make some money. So they attack this for the first time. And as a city, it's your obligation to do the best you can to steer that into constructive engagement. The process has to be somewhat predictable and understandable. And toward that end, Idaho Code 676534 requires that you adopt a hearing procedures resolution or ordinance. This sets forth the standard methods by which public participation will be allowed. This aids in the predictability. If you do not have such a resolution or ordinance, and I recommend a resolution, that's a task that should be undertaken immediately. Again, at the end, the applicant bears the burden of persuasion. So an applicant who is disinterested or fails to take an active role in persuading the decision makers doesn't deserve an approval. It's one of those things that the applicant needs to understand, that his rights are also accompanied by his responsibilities. And that's where the responsibility to persuade doesn't shift to the city, but remains with the applicant. From the staff perspective, from those who serve a city or a county, the staff should project at least a superficial matter of neutrality, even if that can be a challenge. And I believe it can be when you have an applicant who doesn't take his or her responsibility seriously. If the staff knows a way that the applicant can obtain the approval that he or she seeks, they should disclose that. It's not a place to hide the ball, not a way to non-disclose what's going on. So if you know how an applicant could succeed, even if the applicant is sometimes not the most cooperative person in the Western world, let them know how they can make their request happen. And then it's important as staff, you need to have a full picture, but the central focus, needs to be on the issues in controversy. The other things that are uncontested will take care of themselves. So center your efforts on those central or controverted questions and identify them as such. And then as participants arrive to take part in the process, let the applicant and the audience know what will be necessary to create a defensible record. One of the questions that often occurs is, should the staff express an ultimate opinion? Should it advise the governing board or the planning commission that an application should be approved or denied? My experience with this started before such hearings were quasi-judicial as they are today. And over the years, I've formed the view that the staff should remain neutral, identifying areas where there may be shortcomings in persuading or proving compliance with a criterion. But in the end, it should be the governing board who makes the final decision and arrives at the logic that supports or rejects the application in question. Now, we've got the applicant, we've got the city staff, and the public gets invited. This may be the first time that the public has come to a planning and zoning meeting, or maybe even been in City Hall other than to pay a water bill. So they have no experience with this at all. The procedures and the terminology can often sound foreign or unfamiliar. To create a better record, it's important for you to set the stage and identify those things that are critical to understanding what a successful application will be and what would be reasonable grounds for resisting it. For those of you who make decisions or help shape the process, beware of being too friendly with people who are repeated participants. You may know a certain engineer or surveyor, and if you create an impression that that person is a close personal friend, even if they are, which is fine, it may create some suspicion in the audience. So keeping a face of neutrality on during the entirety of the process is much better. And it's the same responsibility that we have to put applicants to their proof, even if we know them and have a friendship with them. The public needs to receive notice of what the decision criteria are going to be, and they need to have explained what will be important and effective from the very outset of the process. If we fail to do this, we allow them to wander off into emotional territory that will not serve any meaningful interest. Another thing, and it's just a practical hint, is take precautions not to load too much on any single agenda, because the governing board could well be overburdened by the difficulty of working through something into the wee hours of the morning. Nobody makes great decisions late at night. Many decision makers have already had a full day. They don't need a dose of nightlife. It's a very difficult thing. If you have too much coming in at any one time, break it up into separate meetings. Perhaps consider a special meeting in order to see that the agenda is digestible. It's sized so that somebody can accomplish what's intended. The decision criteria, and this is a requirement that was generated by the legislature in 2013, need to be central everywhere. The application form you use, the staff reports that are generated, and final decisions need to focus around the decision criteria that are set forth in your ordinances or the statutes. There are different criteria based upon different legal standards. Communication of those decision criteria should start with a first mailed notice. We've all learned how to slim down a notice for publication to avoid the unnecessary cost of publication notice that doesn't reach many, if any, readers. But that doesn't mean that we have to keep our notices so brief when we can put 4 single sheets of letter-sized paper together in our mailings. Those mailings should include additional help on how to participate effectively. Once again, when we get to the hearing, those criteria should be prominently displayed when that agenda item is up for action. And then finally, it's useful to develop a decision worksheet for the decision-making body that contains those applicable criteria in a way that will make them respond to the specific points of persuasion, which must be developed at the time the decision is reached. Those amendments have required the standards to be in our ordinances. It must be set forth in express terms. It shouldn't be uncertain that an applicant needs to ask what must be proven in order to obtain this permit. It's meant to inform the applicant, inform the residents, and to keep the decision makers on track. Identifying the bases for the decision in a written decision is a key statutory requirement. If we don't make our decisions reflect what the law requires, they're going to be subject to invalidation by a reviewing district court. And that process is expensive and time consuming. So we want to do our best to see that the criteria are clearly stated, that we inform participants, and then we apply them in our final decision. I've taken just an example, and it's an example for two reasons. Various basic criteria that may find their way into your consideration. First of all, I've used a subdivision as that example. It's a common thing, and during periods of active development consideration, we can see that subdivisions go through the hearing process a great deal at the governing board level. And it's important to recognize that of all the procedures under the Local Planning Act that do require a public hearing, subdivisions are not one of them. Subdivisions are not required to have a public hearing for an individual subdivision proposal. Almost every community's subdivision ordinance requires one, however. I raised that simply because it's probably also one of the most challenging public hearings that a governing board can experience. When you send out a notice of a public hearing regarding a subdivision in a neighborhood, what most people believe is that you are asking them whether they want to see land subdivided or not. Legally, what you have to be asking them is, do you have any evidence that this proposal does or doesn't meet our subdivision ordinance requirements? If subdivision is not to be allowed, it should be disallowed by zoning the land so that subdivision is not a practical option. The standards I've set forth on this slide indicate things such as road design, circulation, water system capacity and design, sewer system capacity and design, ped paths, street lighting, surface or stormwater management, the presence of bike paths, traffic signs, zoning compliance, etc., etc. All of those are kind of checks the box options. But an applicant must demonstrate that the proposal submitted meets all the standards contained in the subdivision ordinance. Decision makers, however, who don't identify these criteria often wind up fending off claims by neighbors that they don't want subdivision anywhere near them, and that the governing board should have some inherent right to turn that down. The legal answer is subdivisions that meet the ordinance criteria deserve to be approved. So don't paint yourself into that corner. And if you can find other ways to solicit public observations and comments, it may be better than a public hearing in some instances. That's the question that gets posed. When you send the notice of public hearing, do you clearly state the purpose of the hearing? In each instance, The criteria from the ordinance can help steer people who receive your notice. Do you know what those people are perceiving when they get that mailed notice or observe the posted notice on your website? What does the public want? And will it help you reach a final answer? The final answer dictated by your subdivision ordinance. There's always work to be done before you start a public hearing. That work is more involved today when public hearings aren't happening at a particular time and place. Rather, they're happening at a particular time. Public hearings are required for a number of activities under the Local Land Use Planning Act. The Planning Act's actions require public hearings for adoption and changes of subdivision ordinances, zoning ordinances, comprehensive plans, all ordinances, and individual applications from variance to plan unit development. You publish your notices in your official newspaper, something that reaches very few people, and you post them on your website or your social media outlet. When you mail notices, they should go by first class postal service. Never use certified mail. Many people won't pick up a letter from a public agency. You should always also solicit comments from public agencies when you have enough information to make that solicitation useful. The staff report should note compliance or non-compliance with criteria, and it should identify criteria that there may be a question about. Other physical arrangements are appropriate. The standard advice is to make sure your meeting space will accommodate the crowd you anticipate. The same is true for the software you use to invite people to join your meeting electronically. If it has a limitation on number of attendees, make sure that the limit will exceed what you expect to be present electronically. You also need to prepare hearing materials and make them accessible. Making them accessible when your offices are not as open for public involvement as they might normally be is a challenge that's discussed further in the written article I've prepared. Hearing procedures need to be consistent. I mentioned earlier adoption of the Hearing Procedures Resolution, required by Idaho Code 676534. I recommend it be a resolution because resolutions don't need to be published, and because this procedures resolution doesn't govern anybody's conduct in their home or in public space. It only makes a clear delineation of the rules that will apply when somebody appears to participate in one of your public hearings, either in person when the circumstances allow or electronically. It's also important to look, does the adoption of electronic procedures call for amendments to these resolutions to recognize that electronic meetings may be possible? Because right now they are. Alert all potential participants that ex parte contact is not appropriate. In other words, decision makers shouldn't be contacted outside the hearing. It's just like being on a jury. You should not have witnesses calling you to try to provide you with advocacy on for or against any proposal. Make your rules of procedure readily available on your website or accessible on your social media site, and offer to provide them for anybody who requests. Adjust your hearing procedures if you need to allow things to be modified to reflect the current circumstances. Never has anything been more evident than the need to be flexible in these circumstances where in-person participation is not a current possibility. Now, there are two kinds of hearings. I'm not going to spend a great deal of time on the legislative hearing. A legislative hearing is when the city council, or in a recommending format, the Planning and Zoning Commission is going to consider adoption or amendment of a general ordinance. And that all you need is to have a proposal for the ordinance, a public hearing noticed by publication and posting, and an opportunity to be heard. The hearing doesn't have to happen in any particular order, and when it's done, you go on with either your action to enact the ordinance or not. The focus here is to address the quasi-judicial public hearing. And it starts with an introduction by the presiding officer. It may be appropriate that the presiding officer would want the staff to give the ever so brief general location and nature of the application information. With that, it is up to the applicant in the next step to describe the project and to make his or her points as to why the project complies with the legal standards. After that, a summary of the staff report. In my opinion, not giving an ultimate opinion, but rather pointing out areas where concern might be registered. If you use a sign-up sheet that allows comments, the next step would be a good time to read those into the record. As a general rule, any writing received on the night of the hearing needs to be read aloud. Otherwise, the public will never know what's in it, and neither will the decision makers. Following that, you have testimony by supporters of the application. Then after that, those who declare themselves to be neutrals, people who purport to not have a view. Sometimes you may find that their neutrality may be questionable, but the point is, at this point, at the end of the neutral testimony, theoretically, you should have had every positive thing to be said about the application on the record, either in the writings or by any kind of testimony that's been entered. The neutral signals, and by the way, something I omitted, it's important to recognize that at the end of each one of these steps, the chairman should ask if anybody else that fits into that slot has anything further to say. So for the supporters, are there any more supporters? The neutrals, are there any more who are neutral? Once you've done that, then you open the hearing to testimony by the opponents. Sometimes it may be desirable to have a designated spokesperson so that people can cede time to someone who can put together a more integrated argument. The opponents have a right to present their own evidence and to rebut what has been said by the applicant in a staff report, by the supporters, and by the neutrals who preceded them. Sticking with this order of proceedings allows you to avoid subsequent needs for those who have a disagreement with something said after they have spoken to rebut it. So at the end of the opponent's testimony, rebuttal should be allowed by the applicant. Only the applicant, because only the applicant is an active participant in the hearing process. With that, the hearing would close. That's not the end of the story, however. Idaho law requires that planning and zoning matters be decided by a written decision. So, some hints. First of all, if you haven't already, it's a good time to abandon or suspend Robert's Rules of Order. The reason I suggest that, particularly for land use matters, is that Robert's Rules of Order are intended for a body where issues come up spontaneously. Your issues are determined by your agenda. And Roberts has a requirement that you must make a motion and a second before discussing. I think it's far better for you to discuss, and out of those discussions, have somebody develop a motion. The chairman should solicit comments from the commissioners before developing a decision motion. And after everybody's heard from everybody, somebody should try to pull those pieces together, having made notes to reach a decision, identifying the points and the criteria that wind up reaching the conclusion that the commission or council makes. If the decision is routine without serious objections, the motion may stand on its own, particularly if you include a worksheet that checks the necessary boxes and is incorporated into that motion. If the decision is very contentious, highly contested, I think most decision makers would benefit by having their legal and planning support staff develop a final written decision to be brought to them for final action. If developing a recommendation, the Planning Commission should save the time of finalizing everything because the City Council is going to make the ultimate decision. Just make your recommendation and move it on the next step. You don't need to finalize it as if you were preparing for litigation or for a permanent final decision. So, going back to the initial premise, reaching that decision starts with the end in mind. The application forms should inform an applicant what the decision criteria are going to be. When you mail notices, you should do far more than you publish. Let people know what the decision criteria are and what they will be expected to provide persuasive testimony about. Third, it's important to keep everybody on task by displaying the decision criteria in your hearing room. It can be posted by a poster board or projected by a secondary projector. Also, to keep decision makers on task, have decision sheets that identify the criteria and allow room for notes to see that the decision criteria are all addressed. And then finally, that final written decision needs to be approved by the decision makers. They're the ones who are going to be held accountable should anybody appeal to a district court. Appeals. The process has been made more involved in recent years to avoid having people tie down procedures with a district court appeal that lasts a year and a half merely for the cost of filing an appeal notice. So now, anybody who wants to appeal must notify possible appellants. That's your job as a city to let the potential appellants know that they have to provide a reconsideration request before they can appeal to district court. That has to be done within 14 days of the final decision. So that means you must notify both those who attend the hearing and those who are applicants of this reconsideration appellate process. And then it is incumbent upon the decision makers to consider only specific identified errors that the appellant has made. And then the decision makers are given the choice of either saying, no, we're going to stand by our initial decision, or we're going to entertain another public hearing and consider the objections that have been raised, and within 60 days, reach our final decision after reconsideration. All of these steps are ones that are a precursor to a judicial appeal. And if they aren't followed, it may be possible for the agency to object to the appeal on the grounds that the administrative remedies weren't exhausted. When judicial review takes place in the district court, the court will look at the final decision and the decision-making process. You need to maintain a transcribable verbatim record. They will examine that transcription if anybody identifies issues associated with it. They will address the decision criteria and the rationale that you use to support it. The decisions will then be judged upon, as the legislature said, sound reason and practical application of recognized principles of law. So it's not going to be a hyper-technical review that focuses upon the meaning of it. It is going to be, did you address the criteria and did you apply them in a reasonable and rational way? The remedies available typically are to reverse a decision, and it's only a remedy if there's actual harm or violation to the fundamental rights of a petitioner, an appellate. I hope these are somewhat helpful guides. The circumstances of carrying out public hearings with nobody there are very substantial. I repeat my comment at the outset. If you find you don't have to make public hearing decisions in the short run, it may be better to wait until time allows them to be carried out in person. But if the clock is ticking and you must take steps, recommend the foregoing procedures as an efficient way to help you get to a decision that will stand the test of time and also appellate review. I hope you will continue your service to your communities. We thank you for watching us on this video, and we hope that the days ahead will be brighter and with many great community opportunities presented for all of you. Thank you for watching.